Ladies and gentlemen, this video is done under Pan India Legal Literacy and Legal Awareness Program conducted by Center for Environmental Law Education, Research and Advocacy, National Law School of India, University, Bangalore, under the aegis of Department of Justice, Ministry of Law and Justice, Government of India. The topic on which I'm going to speak for a few minutes is protection of women from domestic violence. I'll not be critically analyzing the provisions of the Act. Rather, the purpose of this video is to create a legal awareness as to what are the relief which are available to the women who are subjected to domestic violence. When we look into the need for this particular legislation, Protection of Women from Domestic Violence Act 2005, there was a violence which was committed against the women in the household, and National Family Health Survey conducted in 2015-16 makes it very clear 30% of the women in India are subjected to sexual or physical abuse in the household. So there was a need to prevent this particular domestic violence, and the government has passed this legislation in the year 2005, and it has come into force in the year 2006. When we look into the statement of objects and reasons of this act, it makes very clear that this law is being passed to provide for more effective protection of rights of women guaranteed under the Constitution. Preamble of the Constitution itself secures equality. Article 21 of the Constitution makes it very clear that right to life includes right to live with human dignity. No doubt, when there is domestic violence committed against women, it amounts to violation of Article 21 of the Constitution. And the Constitution has also imposed a fundamental duty on every citizen under Article 51A, subclause E, to renounce the practices which are derogatory to the dignity of women. So a law was necessary to prevent this particular domestic violence, and if already being committed, to prevent the reoccurrence of this particular domestic violence. When we look into the scope of this legislation and its application, Protection of Women from Domestic Violence Act is applicable throughout the territory of India. In 2019, it was extended to the whole territory of India, including Jammu and Kashmir. Before understanding some of the important provisions of this act, it is very much essential to understand some of the definitions which are provided under the act. I'm not going to look into the legal jargon or a technicality which is included in defining these terms. I'll simplify it and explain it so that it would be better for a viewer to understand it in a simplified manner. Who is an aggrieved person? See, in simple words, aggrieved person under this legislation is a woman who is subjected to domestic violence. Section 2A of the Act defines aggrieved person means any woman who is or has been in a domestic relationship with the respondent. But in simple words, we can understand any woman who is being subjected to domestic violence is an aggrieved person under the law. The next important aspect, what we need to understand is who is respondent. Respondent is a person, a male member who has committed domestic violence against a woman. Section 2Q of the Act says Respondent means any adult male person who is or has been in a domestic relationship with the aggrieved person. So for the purpose of simplification, we can understand aggrieved person is the woman against whom the domestic violence is being committed. Respondent is the male person, adult male person who has committed domestic violence against women. What amounts to domestic violence? ಈ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯ ಅಂದ್ರೆ ಏನು? ಯಾವ ಕೃತ್ಯ ಅಥವಾ ಯಾವ ಸನ್ನಿವೇಶದಲ್ಲಿ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯ ನಡೆದಿದೆ ಅಂತ ಪರಿಗಣಿಸಬಹುದು. Section 3 defines domestic violence. When can we say that domestic violence is being committed? Section 3 says any act, omission, or commission or the conduct of a respondent is that which harms or injures or endangers the health, safety, life, limb, or well-being of the aggrieved person. It also includes causing physical abuse, sexual abuse, verbal or emotional abuse, and economic abuse. When we look into Section 3 of Domestic Violence Act, it is a very vast definition. It includes in itself any kind of harm, injury, abuse, which is being done against women. Physical abuse means any injury which is caused to women physically, kicking, beating, slapping, which harms or which threatens the life or limb of a woman. Sexual abuse includes any conduct which is of such nature which causes bodily pain to women in the course of sexual intercourse, forcing women to view pornography, having a sexual intercourse against her will can be brought within the purview of sexual abuse. Verbal and emotional abuse, insulting, ridiculing, humiliating, or repeatedly threatening to cause a pain or injury to any person whom the aggrieved person is interested. Economic abuse includes deprivation of all or any economic or financial resources to which aggrieved person is entitled. Now, let us move on towards understanding who can claim protection under this act, Protection of Women from Domestic Violence Act. ಯಾರು ಈ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಪರಿಹಾರ ಪಡ್ಕೊಳ್ಬಹುದು, ರಕ್ಷಣೆ ಪಡ್ಕೊಳ್ಬಹುದು ಅನ್ನುವಂತ ಒಂದು ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಏನಂತ ಹೇಳಿದ್ರೆ, it is not necessary that a woman has entered into an institution of marriage to get protection under this act. All women, married and unmarried, they can claim protection under this act. Mother, sister, wife, widow, or partners living in a shared household can also claim protection under this act. Now, the next question arises as to ಈ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯ ನಡೆದಾಗ ಯಾರಿಗೆ ಇದನ್ನ ತಿಳಿಸಬೇಕು? ಇದು ಲಿಖಿತ ರೂಪದಲ್ಲಿ ಇರಬೇಕಾ, ಮೌಖಿಕವಾಗಿ ನಾವು ಇದನ್ನ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಬಹುದಾ ಅನ್ನುವಂತ ಒಂದು ಕುತೂಹಲ ಹಾಗೂ ಡೌಟ್. When we look into the provisions of the act, it is very clear that an information to the protection officer can be made either in oral or written form. So ಇದನ್ನ ಲಿಖಿತ ರೂಪದಲ್ಲೇ ಕೊಡಬೇಕು ಅನ್ನುವಂತ ಅವಶ್ಯಕತೆ ಏನೂ ಇಲ್ಲ. An information can be made to the protection officer either in oral or written form. Who can file? Who can give information? Who can file complaint? When we look into this particular aspect, who can file a complaint? Any aggrieved person, as I have already told. Aggrieved person means women who has been subjected to domestic violence, or a protection officer. The Act provides for appointment of protection officer under Section 8 of the Act. And any person on behalf of aggrieved person can file a complaint, can make an application, can bring it to the notice of a protection officer. So when we read Section 4 of the Act, it is very clear. An information to the protection officer with regard to domestic violence which is being committed can be made orally or in written form. Now, complaint against whom? Against whom we can give a complaint under this particular act? ಯಾರ ವಿರುದ್ಧ ಈ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದು? Any adult male member who has been in a domestic relationship with women. ಯಾವುದೇ ಒಬ್ಬ ಪುರುಷ ಸದಸ್ಯ who is in domestic relationship with women, a complaint can be lodged against that particular person, including husband, relatives of husband, or a male partner. When I say domestic relationship with the respondent, this domestic relationship can arise out of consanguinity, marriage, or any particular relationship in the nature of marriage can very well be brought within the purview of the term domestic relationship. Now, the next important question which comes to our mind is, ಯಾರಿಗೆ ಈ ಮಾಹಿತಿ ಕೊಡಬೇಕು? ಯಾರ ಹತ್ರ ಈ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಅನ್ನ ಮಾಡಬಹುದು? ಯಾವುದೇ ಒಂದು ಮಹಿಳೆ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯಕ್ಕೆ ಒಳಪಟ್ಟಲ್ಲಿ she can approach the nearest police station. She can provide an information or complaint to the police officer, the station in charge of that particular police station, or to the protection officer who is being appointed by the state government under Section 8 of the Act, or a service provider. The Act also provides for registration of service providers, and there are so many NGOs which works for the cause of protection of interests of women. A woman who is subjected to domestic violence can also approach a service provider and provide an information with regard to the violence, domestic violence, which is being committed against her. Or the aggrieved person can directly make an application to the magistrate, that is judicial magistrate, first class, JMFC, under Section 12 of the Act. ಯಾರಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡಬೇಕು ಅನ್ನುವಂತ ಒಂದು ಮಾಹಿತಿ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ, ಯಾವುದೇ ನಿಯರೆಸ್ಟ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಅಥವಾ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫೀಸರಿಗೆ ಅಥವಾ ಸರ್ವಿಸ್ ಪ್ರೊವೈಡರಿಗೆ ಅಥವಾ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟಿಗೆ ಡೈರೆಕ್ಟ್ ಆಗಿ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಬಹುದು. Another important doubt which arises in the minds of aggrieved person is, when can relief be availed? ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಪರಿಹಾರ ಪಡ್ಕೊಳ್ಬಹುದು ಅನ್ನುವಂಥದ್ದು ಮತ್ತೊಂದು ಪ್ರಶ್ನೆ. ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯಕ್ಕೆ ಒಳಪಟ್ಟ ನಂತರ ಮಾತ್ರ ನನಗೆ ಈ ಕಾಯ್ದೆ ಅಡಿ ಪರಿಹಾರ ಇದೆಯಾ, ಅಥವಾ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯಕ್ಕೆ ಒಳಪಡುವಂತ ಸನ್ನಿವೇಶ ಇದ್ದಾಗನೇ ನಾನು ಈ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಪರಿಹಾರ ಪಡ್ಕೊಳ್ಬಹುದಾ ಅನ್ನುವಂತ ಒಂದು ಪ್ರಶ್ನೆ ಉದ್ಭವ ಆಗ್ತದೆ. When we look into the provisions of the Act, especially Section 18 and Section 4 of Protection of Women from Domestic Violence Act, makes us very clear that even before domestic violence is being committed, that is, there is a possibility that the domestic violence is going to take place. It is very likely that the domestic violence is going to take place. Even in such situation, we can avail relief under Protection of Women from Domestic Violence Act. ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯ ನಡಿಲೇಬೇಕು ಅಂತೇನಿಲ್ಲ. ನಡೀತಕ್ಕಂತ ಸಂದರ್ಭ ಇದ್ದಲ್ಲಿ prima facie, if we can prove before the magistrate that there is every likelihood and the domestic violence is likely to take place, the magistrate can issue a protection order under Section 18 of the Act. ಈ ಒಂದು ಕಾಯ್ದೆಯಲ್ಲಿ ನೀಡಿರತಕ್ಕಂತ ಪರಿಹಾರ ಸಿಕ್ಕಬೇಕಾದ್ರೆ ಎಷ್ಟು ಟೈಮ್ ಬೇಕಾಗ್ತದೆ? ವಾಟ್ ಇಸ್ ಅ ಟೈಮ್ ಲಿಮಿಟ್? ಹಲವಾರು ಬಾರಿ ಈ ದೌರ್ಜನ್ಯಕ್ಕೆ ಒಳಗಾದ ಮಹಿಳೆಯರ ಮನಸ್ಥಿತಿ ಹೇಗಿರ್ತದೆ ಅಂತ ಹೇಳಿದ್ರೆ, when I invoke the jurisdiction of courts, it may take a very long time to get a remedy, so better not to avail the remedy at all. But when we look into the provisions of the Act, especially Section 12 of Domestic Violence Act, makes it very clear from the date of making an application to the magistrate that there is a commission of domestic violence, the first hearing will start within 3 days. So the first hearing will start not beyond 3 days. ಅರ್ಜಿ ಕೊಟ್ಟಂತಹ 3 ದಿನಗಳ ಒಳಗಾಗಿ ಫಸ್ಟ್ ಹಿಯರಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ. And the magistrate shall make an endeavor to dispose this particular application within 60 days. 60 ದಿನಗಳ ಒಳಗಾಗಿ ಪರಿಹಾರನ ಒದಗಿಸಬೇಕಾಗ್ತದೆ. ಕಾಯ್ದೆಯಲ್ಲಿ ಇದು ಬಹಳ ಸ್ಪಷ್ಟವಾಗಿ ಬರೆದಿದ್ದಾರೆ. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ shall make an endeavor. He should make all possible efforts to dispose of the application within 60 days. ಹಾಗೆ ಮಹಿಳೆಯರ ಮನಸ್ಸಿನಲ್ಲಿ ಯಾವುದೇ ರೀತಿ ಗೊಂದಲ ಇರಬೇಕಾದಂತ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. 3 ದಿನ ಒಳಗಾಗಿ ಫಸ್ಟ್ ಹಿಯರಿಂಗ್ ನಡೀತದೆ. 60 ದಿನದ ಒಳಗಾಗಿ ಪರಿಹಾರ ಸಿಕ್ಕುವಂತ ಎಲ್ಲಾ ಸಾಧ್ಯತೆಗಳು ಈ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಇದೆ. ಬಹಳ ಮುಖ್ಯವಾದಂತ ಅಂಶ ಏನು ಅಂದ್ರೆ, ಯಾವೆಲ್ಲ ಪರಿಹಾರಗಳು ಈ ಕಾಯ್ದೆಯಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ? What are the reliefs available under this particular act when domestic violence is being committed? What are the reliefs to which an aggrieved person is entitled to? So the reliefs available under Domestic Violence Act or protection order. Protection order is dealt under Section 18 of Protection of Women from Domestic Violence Act. Magistrate can issue a protection order in favor of aggrieved person and prohibit the respondent. Respondent andre ಯಾರು ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯನ ಮಾಡಿದ್ದಾರೆ ಅವರ ವಿರುದ್ಧ ಈ ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್ ಅನ್ನು ಜಾರಿಗೊಳಿಸಬಹುದು. And prohibit the respondent from committing any act of domestic violence. Magistrate may issue an order to prohibit the respondent from committing any act of domestic violence or aiding or abetting in commission of acts of domestic violence. Section 18 ಕೆಳಗಡೆ ಅವನು ಪುನಃ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯನ ಎಸಗಬಾರದು ಮತ್ತು ಎಸಗುವಂತ ಸನ್ನಿವೇಶಕ್ಕೆ ಪ್ರೋತ್ಸಾಹನೂ ಕೊಡಬಾರದು, ಅದರಲ್ಲಿ ಭಾಗಿನೂ ಆಗಬಾರದು. And magistrate can issue an order under section 18 that the respondent is not supposed to enter to the place of employment of aggrieved person. ಆ ಮಹಿಳೆ ಕೆಲಸ ಮಾಡತಕ್ಕಂತ ಸ್ಥಳಕ್ಕೆ ಅವನು ಭೇಟಿ ಕೊಡುವ ಹಾಗಿಲ್ಲ. ಹಾಗೂ ಆರ್ಡರ್ ಅಲ್ಲಿ he cannot commit domestic violence even through phone, email or any other electronic mode. ಅದೇ ರೀತಿ residence order. Section 19 deals with residence order. Magistrate can also issue a residence order restraining a respondent from dispossessing or in any other manner disturbing the possession of aggrieved person from the shared household. ಮಹಿಳೆ ಆ ಮನೆಯಲ್ಲಿ ಇರತಕ್ಕಂತ ಹಕ್ಕು ಸ್ವಾತಂತ್ರ್ಯ ಅವಳಿಗೆ ಇರ್ತದೆ. ಅದಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಡ್ಕೊಳ್ತಕ್ಕಂಥದ್ದಲ್ಲ. ಕೆಲವೊಂದು ಸನ್ನಿವೇಶಗಳಲ್ಲಿ ನ್ಯಾಯಾಲಯ can direct the respondent to remove himself from the shared household and restrain the respondent or any of his relatives from entering any portion of the shared household. ಆ ಮನೆಯ ಯಾವುದೋ ಒಂದು ಭಾಗಕ್ಕೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಥವಾ ಅವನ ಕುಟುಂಬದವರು ಅಲ್ಲಿ ಪ್ರವೇಶ ಮಾಡದೇ ಇರುವ ಹಾಗೂ ಕಾನೂನಿನಲ್ಲಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದಾಗಿದೆ. ನ್ಯಾಯಾಲಯ ಡೈರೆಕ್ಷನ್ ನ ಕೊಡಬಹುದಾಗಿದೆ ಸೆಕ್ಷನ್ 19 ಕೆಳಗಡೆ. ಅದೇ ರೀತಿ ಮಾನಿಟರಿ ರಿಲೀಫ್ಸ್. ಈವನ್ a woman who is subjected to domestic violence can also claim a monetary relief under section 20 of the act. When a domestic violence is being committed against a woman, as a result of domestic violence, she may suffer the loss of earnings, or she may have to incur medical expenses, or she incurs the loss caused due to the destruction or damage or removal of any property from the control of the aggrieved person. In all such cases, the magistrate is having a power to issue an order under section 20 of the act. He can provide a monetary relief to the aggrieved person. So whatever aggrieved person has suffered because of commission of domestic violence, magistrate can issue an order and thereby provide monetary relief. Section 21 of the act deals with custody orders. Temporarily, the magistrate is also having a power to grant the custody of any child or children to the aggrieved person or to the person making an application on her behalf under section 21 of the Persons Protection of Women from Domestic Violence Act. And lastly, the magistrate is also having power to issue an order under section 22 of the act and thereby award compensation to the aggrieved person. Magistrate can pass an order directing the respondent to pay any compensation or damages for the injuries, including mental torture, emotional distress caused by domestic violence committed by the respondent. So ಮಾನಸಿಕವಾಗಿ ಉಂಟಾದಂತ ಆಘಾತಕ್ಕೆ ಅಥವಾ ಮಾನಸಿಕ ಕಿರುಕುಳಕ್ಕೆ ಅಥವಾ ಯಾವುದೇ ರೀತಿ ಇಂಜುರಿ ಸಫರ್ ಮಾಡಿದ್ದಕ್ಕೋಸ್ಕರ ಆ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯಕ್ಕೆ ಒಳಗಾದ ಮಹಿಳೆ ಕಾಂಪನ್ಸೇಷನ್ ಅನ್ನು ಕೇಳಬಹುದು. And magistrate is having a power to issue an order directing the respondent to pay compensation for the injuries suffered by the aggrieved person. So ಈ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಹಲವಾರು ಪರಿಹಾರಗಳಿದೆ. ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್, she can seek a protection to prevent the reoccurrences of domestic violence. Residence order, she can claim her right to reside in a shared household, and she can claim a monetary relief for the losses of earnings which she has suffered due to domestic violence. She can also seek the custody of a child or children. In addition to all these things, she can also claim a compensation for an injury suffered, a mental distress. And moving further, Act also provides for shelter home, medical facility. ಯಾವುದೇ ಒಂದು ಮಹಿಳೆ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯಕ್ಕೆ ಒಳಪಟ್ಟಲ್ಲಿ ಕೆಲವೊಂದು ಸಂದರ್ಭದಲ್ಲಿ ಆ ಕ್ಷಣಕ್ಕೆ ಅವಳು ಮನೆಯಿಂದ ಹೊರಗಡೆ ಬರಬೇಕಾಗ್ತದೆ. ವೇರ್ ಟು ಗೋ, ವಾಟ್ ಟು ಡೂ. ಮನೆಯಿಂದ ಹೊರಗಡೆ ಬಂದ್ಬಿಟ್ರೆ ನಾನು ಎಲ್ಲಿ ಹೋಗ್ಲಿ, ನನಗೆ ಯಾರು ವಸತಿ ಕೊಡ್ತಾರೆ, ಎಲ್ಲಿ ನೆಲೆ ಸಿಗತ್ತೆ. ಈ ಕಾಯ್ದೆಯಲ್ಲಿ ಸೆಕ್ಷನ್ 6 ಪ್ರಕಾರ ಶೆಲ್ಟರ್ ಹೋಮ್ಸ್ ನ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿರುತ್ತೆ ಸರ್ಕಾರ. ಅಂಡ್ ಇಟ್ ಈಸ್ ಅ ಡ್ಯೂಟಿ ಆಫ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫೀಸರ್ ಟು ಎನ್ಶೋರ್ that this aggrieved person will get a proper shelter. ಯಾವುದೇ ಒಂದು ಮಹಿಳೆ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯಕ್ಕೆ ಒಳಪಟ್ಟು ಮನೆಯಿಂದ ಹೊರಗಡೆ ಬಂದಂತ ಸನ್ನಿವೇಶದಲ್ಲಿ ಸೆಕ್ಷನ್ 8 ಕೆಳಗಡೆ ಅಪಾಯಿಂಟ್ ಆಗಿರ್ತಕ್ಕಂಥ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫೀಸರ್ಸ್ ನ ಕರ್ತವ್ಯ ಏನಿರುತ್ತೆ ಅಂದ್ರೆ ಅವರಿಗೆ ಒಂದು ಸೂಕ್ತವಾದಂತಹ ವಸತಿ ಕಲ್ಪಿಸಿಕೊಡುವಂಥದ್ದು. ಅಟ್ ದ ಸೇಮ್ ಟೈಮ್ ದೇ ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಟು ಅ ಮೆಡಿಕಲ್ ಏಡ್. And a woman who is subjected to domestic violence is also entitled for a medical facility under section 7 of persons of protection of women with domestic violence act. ಇದರ ಜೊತೆಗೆ the act also provides for appointment of protection officers and provides for their duties and functions. And there are also duties of police officers, service providers, and magistrate. ಯಾವುದೇ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯಕ್ಕೆ ಒಳಪಟ್ಟು ಮಹಿಳೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ ಹಾಜರಾದಲ್ಲಿ ಅಥವಾ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫೀಸರ್ನ ಒಂದು ಭೇಟಿ ಮಾಡಿದಲ್ಲಿ ಈ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್, ಸರ್ವಿಸ್ ಪ್ರೊವೈಡರ್ಸ್ ಮತ್ತು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟಿಗೆ ಕೆಲವು ಡ್ಯೂಟಿಗಳನ್ನ ಕಾಯ್ದೆಯಲ್ಲೇ ವಿಧಿಸಿದ್ದಾರೆ. ಸೊ ವೆನೆವರ್ a aggrieved person approaches the protection officer should make a domestic incident report. Form 1 is being provided under the act. ಅದರ ಪ್ರಕಾರ ಒಂದು ಡೊಮೆಸ್ಟಿಕ್ ಇನ್ಸಿಡೆಂಟ್ ರಿಪೋರ್ಟ್ ಅನ್ನು ತಯಾರಿಸಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟಿಗೆ ಮತ್ತು ಆ ಸ್ಟೇಷನ್ ಇನ್ಚಾರ್ಜ್ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸಿಗೆ ಕಳಿಸಿಕೊಡ್ತಕ್ಕಂಥದ್ದು. ಹಾಗೂ ಆ ಒಂದು ಅಗ್ರೈಡ್ ಪರ್ಸನ್ನಿಗೆ ಕಾನೂನಿನ ನೆರವು ಸಿಗುವ ಹಾಗೆ ನೋಡ್ಕೊಳ್ತಕ್ಕಂಥದ್ದು. ಹಾಗೂ ಲಿಸ್ಟ್ ಆಫ್ ಸರ್ವಿಸ್ ಪ್ರೊವೈಡರ್ಸ್, ಯಾವ NGOಗಳು ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ಕಾರ್ಯನಿರ್ವಹಿಸ್ತಾ ಇದ್ದಾವೆ ಅದರ ಮಾಹಿತಿ ಕೊಡ್ತಕ್ಕಂಥದ್ದು. ಅಂಡ್ ಟು ಗೆಟ್ ದ ಅಗ್ರೈಡ್ ಪರ್ಸನ್ ಮೆಡಿಕಲಿ ಎಕ್ಸಾಮಿನ್ಡ್. All these are duties of protection officer, and there are duties of service providers also. Protection officer ಹತ್ರ ಹೋಗದೆಲೆ ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯಕ್ಕೆ ಒಳಗಾದಂತ ಮಹಿಳೆ ಈ ಸರ್ವಿಸ್ ಪ್ರೊವೈಡರ್ಸ್ NGOಗಳ ಹತ್ರ ಹೋದ್ರೂನು ಅವರುನು the service providers should get the aggrieved person medically examined. They have to record the domestic incident report and send this domestic incident report to the nearest police station as well as magistrate, and ensure that the aggrieved person is provided proper shelter. And the magistrate is also having a duty to make this aggrieved person know as to what are the reliefs available, and the aggrieved person can also file a case under section 498A of IPC, and there is a legal aid which is available to the aggrieved person. And lastly, is there any penalty for breach of protection order? When an aggrieved person approaches the magistrate and makes an application under section 12, magistrate can issue a protection order. ಆ ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್ ಅನ್ನ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪಾಲಿಸದೆ ಹೋದ್ರೆ, ಅದನ್ನ ಉಲ್ಲಂಘನೆ ಮಾಡಿದ್ರೆ ಏನು ಶಿಕ್ಷೆ ಇದೆ, ಯಾವ ರೀತಿ ಪೆನಾಲ್ಟಿಯನ್ನು ವಿಧಿಸಿದ್ದಾರೆ ಅಂದ್ರೆ, there can be an imprisonment which may extend up to 1 year, or a fine which may extend up to rupees 20,000, or both. So the person who contravenes to the protection order issued by the magistrate under section 18 can be punished with an imprisonment which may extend up to 1 year and a fine up to 20,000, or with both. Now, the most important thing is, most of the times there are women who are illiterate, ignorant, downtrodden, economically unaffordable, and for them, they cannot understand the provisions of the act. For them, what they can do is, there are so many helpline numbers. Women can call these numbers, and most of the numbers are toll-free numbers. Any woman who is in distress because of domestic violence or any other reason can dial 181. This is a women helpline launched by the Ministry of Women and Child Development, Government of India. And in the same way, women can dial 112 to seek help from Karnataka Police during an emergency, including domestic violence. A woman can dial 1091 Sahayavani, launched by Karnataka government, a dedicated 24-hour helpline to protect women and to ensure their safety and security. Or a woman can approach Karnataka State Commission for Women. The number is 080-222-16485. And beyond this, a woman who suffers from domestic violence can also register online complaint in the official website of National Commission for Women. National Commission for Women website ಗೆ ಹೋಗಿ ncwapps.nic.in ಈ ವೆಬ್ಸೈಟ್ ಗೆ ಹೋದ್ರೆ ರಿಜಿಸ್ಟರ್ ಆನ್ಲೈನ್ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನುವಂತ ಒಂದು ಹೈಪರ್ ಲಿಂಕ್ ಇರ್ತದೆ. ಅದರ ಮೇಲೆ ಕ್ಲಿಕ್ ಮಾಡಿದ್ರೆ ವಿ ಕ್ಯಾನ್ ರಿಜಿಸ್ಟರ್ ಆನ್ಲೈನ್ ಕಂಪ್ಲೇಂಟ್. ಯಾವುದೋ ಒಂದು ಮಹಿಳೆಗೆ ಮನೆಯಿಂದ ಹೊರಗಡೆ ಹೋಗ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ, ಪೊಲೀಸನ್ನು ಅಪ್ರೋಚ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ, ಪ್ರೊಟೆಕ್ಷನ್ ಆಫೀಸರ್ ಅನ್ನು ಅಪ್ರೋಚ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ, NGO ನ ಫಿಸಿಕಲಿ ಮೀಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಅಂತ ಮಹಿಳೆಯರು they can dial 181, 112, 1091 or call State Women's Commission and register online complaints through official website of National Commission for Women, and you can check the status of your complaint also. ಏನಾಗಿದೆ ಸ್ಟೇಟಸ್, ಯಾವ ಸ್ಟೇಟಸ್ ಅಲ್ಲಿ ಇದೆ ನಾನು ಮಾಡಿರ್ತಕ್ಕಂಥ ಲಾಡ್ಜ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನೋದನ್ನು ತಿಳ್ಕೋಬಹುದು. To conclude, we are celebrating Azadi Ka Amrit Mahotsav. So 75 years of independence we are celebrating everywhere in our country. And this will be meaningless if we are not preventing domestic violence committed against women. This celebration will be meaningful only when we put an end to this domestic violence, and mere recognition of rights through constitution or statutes cannot yield to desired result. The citizens should join the hands with state in realization of constitutional goals and objectives of legislation, unless the society responds to the legislations passed by the state, it is very difficult to achieve the desired result. Hope this video has sensitized the male members of society, and we believe that they are not going to commit any domestic violence in their families. At the same time, I hope this video has also created a legal awareness to women as to what are the remedies which are available when domestic violence is being committed. Finally, I thank National Law School of India University, CEERA, Professor Sai and his team for associating me in this noble cause of creating awareness through Department of Justice project. Thank you.